Good morning, everyone. We're just going to give everyone a few minutes or a minute or two to get into the webinar room and we'll get started. It looks like we have a few people joining right now. Okay, so I think we'll go ahead and get started as people trickle in. Welcome to the first Your Morning Briefing of 2026, a monthly webinar series designed to keep you informed and ahead of the curve on labor and employment topics, all in the time it takes to finish your morning cup of coffee, which I have right here. You'll notice that we're on a different set today. Um, where Ben and I are in different locations this morning. And I'm stuck at home because of the snowy weather in Buffalo at the moment. So we're coming to you from a different set, but hopefully we'll be back to our normal routine in the next month. But to get back to our introduction, my name is Anna McCarthy, and I'm joined by my co-host this month, Ben Mudrick.
Hi, good morning, everyone. And I forgot to mention her title, partner. She was recently promoted to be a partner here at the firm. So congratulations, Anna. Uh, we're
Thank you.
excited for you. And yeah, great to be here. I'm filling in for Amy, who couldn't make it today, but she'll be back next month.
All right, so we'll dive right in. During today's Your Morning Briefing, we're going to talk about a law that was signed by Governor Hochul at the end of December, right before many of you may have been off for the holidays. So it may have taken you a little bit by surprise. It's called the Trapped at Work Act, a bit of a dramatic title. In this section, we're going to talk about how the act impacts employers and what are sometimes called stay or pay provisions. You may have heard that term. You may have a provision that could be considered a stay or pay provision in your policies or agreements. So that generally refers to agreements that require employees to repay some sort of expense when they leave employment. So we'll be talking about how this Trapped at Work Act impacts those types of provisions.
Yeah, and when we think about the act, this is one of the common things that happens in New York State. The legislature sees a problem, and the problem is they are worried that employees can't go to another job because they're forced to repay something. So, I take this other job, but if I leave, I owe the employer $5,000 or $10,000, and I can't repay that, so I get stuck. So they wanted to fix this problem, but in doing so, they drafted a piece of legislation that really nobody understood and was confusing. Even the governor, and we'll talk about this, but the governor even said, this is confusing. So we're in this weird spot where you probably saw a lot of headlines from law firms or news agencies that say, hey, this Trapped at Work Act passed. It's effective immediately. You need to change everything. But now, as you'll learn on this webinar, if you haven't been paying attention to it, the answer is kind of, well, it's in effect, but let's slow down a little bit because there's some time to figure things out. So that's what we're going to talk about today. The law at first blush seems like it's a huge change and you have to review every employment agreement. It's actually now pretty tailored. So it may not require huge changes, but you need to look at your agreements and your processes and make sure that you're compliant going forward. So we're going to talk about the initial law, the revision of the law, and then kind of what you need to do going forward to make sure you're on the right side of it.
Yeah, exactly. Before we dive in, though, I'm just going to cover our normal housekeeping items. This webinar has been approved for a half credit of HRCI and SHRM credit, as well as CLE credit. And we'll give some instructions for how to submit for that later and give you the codes. It's intended for general information purposes only and shouldn't be considered as legal advice. As per usual, all of your lines are placed on mute. So if you have any questions, please use the Q&A feature on your toolbar. Don't use the raise hand feature or the chat function because we won't see those as we're presenting, but we will see the questions in the Q&A. Feel free to submit at any time. We'll try to address questions as they come up during the half hour, but if not, we'll try to reserve some time at the end for your questions. So back over to Ben. Ben, you were just saying that there is an original act and then there's some modifications. So why don't we start with the original? What did that cover?
Yeah, so on December 19th of 2025, back when all of us were trying to get things out the door at the end of the year and trying to buy presents and do all those things, the governor signed a law called the Trapped at Work Act. And the law, according to its terms, took effect immediately. So as of December 19th, 2025, this new law was in place. and not a lot of time to think about and prepare for it. What the law essentially said was that employers, which is a very broad term, includes everyone on this call, probably includes public employers, private employers, government entities, all those things. Employers were prohibited from requiring employees to sign promissory notes or employment promissory notes that they would have to repay upon termination of employment. Now, that term promissory note, that's part of the confusion. It was defined as any agreement that requires an employer, I'm looking at the language here, that requires an employee, a worker to pay an employer if the worker leaves employment before the expiration of a stated period of time. So when we first read that, I think a lot of people took a step back and said, oh my gosh, that covers all sorts of things. It could cover relocation bonuses. It could cover retention bonuses, training costs. If you pay somebody to get an MBA and they have to repay it, are all those things banned? And the way the law was written, it made clear that that definition of promissory note included costs related to the repayment of training for an employer, but it didn't say that was the only thing it covered. And there were some exceptions into the law for other expenses, like sums advanced by an employer, or things provided under a collective bargaining agreement. But the language is very ambiguous. So, lawyers and HR representatives and everybody read this and said, well, what's covered and what's not covered under this law? It also had penalties. So if an employer had an agreement that was illegal under the law, an employee could go to the Department of Labor and get thousands of dollars of penalties, injunctive relief, all those things. And if an employer sued an employee under one of those agreements that was now void, employees had the chance to recover attorney's fees for that. So it was confusing the way the law, well, it still is because this is the law that's in effect still, but it's confusing. We think the legislature's intention was try to prohibit these training requirements. An employer says, I'm going to pay you to get a plumbing license, or I'm going to have some in-house classes to teach you how to do HVAC, but that costs a certain amount of money. And if you quit, you got to pay me for that. That was the intention, but the way the law was written, we had those questions. Well, what if I pay an employee $10,000 in moving expenses and they quit after a month? Do they have to repay me? Is it against the law for me to have that agreement? And the law was written to say that all types of agreements of that sort are null and void and in violation of public policy. So we think what happened was the legislature had identified kind of a problem that was a smaller problem, this training issue. But the way the law was written, it seemed to go way beyond. So we all saw the law. We thought, well, what do we do with this thing? The governor had similar thoughts. And why she signed it, I don't know, but Anna can talk about that part of it.
Yeah, so when she signed it, simultaneously with her signing, she issued an approval memorandum that pointed out her concerns with some of the ambiguity and maybe unintentional prohibitions that were sort of baked into the law, into the original version of the law that Ben just described. So when she signed it, her approval memorandum said that this bill, generally speaking, Ben, as you just described, would prohibit employers from requiring employees to pay their employer if they leave their job. And so that would be things like training repayment agreement provisions or other stay or pay contracts that force employees, as she said, to stay in their jobs that they don't want because of the threat of financial penalty. So she's talking about what she termed to be sort of exploitative agreements, repayment agreements. That being said, because the bill was drafted somewhat ambiguously, she believed that it would also prohibit voluntary tuition assistance programs that actually provide benefit to employees. So if an employee wants to go and get an additional training credential or educational credential, some other type of title that would help them in their careers, not just at their current employer, but for their whole professional career, some employers will provide tuition assistance to do those things. So that's a real benefit to employees. And the way that this original law was written in its current form, and it still is right now, it would potentially prohibit those types of things, as well as other agreements that Ben talked about. So she said, with simultaneous with the signing, that she reached an agreement with the legislature to address those concerns in the upcoming legislative session. So on that basis, on that agreement, she signed the bill into law. So there was this idea that there would be proposed amendments pretty shortly thereafter to modify the law and address these ambiguities. So Ben, I'm going to turn it back to you to talk about what the proposed amendments are to this bill or
Yeah,
to the
so
law.
behind the scenes, when the governor was considering the agreement or the law and whether she's going to sign it or not, there was actually we understand discussions going on behind the scenes, and she had been talking to the leaders of the legislature, and she had essentially said, "Look, I'm going to sign the law, but on the understanding that we're going to propose these amendments and they're going to pass, and then the law will be modified." So we are in a position as of today where we have this initial version of the law that has passed and has taken effect. But we have amendments that have been proposed that are sitting in the legislature and we understand will be signed shortly, but we can't promise that, right? Who knows what's going to happen? But I think all employment lawyers think that they are going to pass. And what I'm going to talk about next will be what the law actually means to you going forward. But we are in this kind of limbo state right now. So just keep that in mind. Nobody should be freaking out. I don't think you need to make big changes right now. But what we're going to talk about in these amendments they have not taken effect yet. But if they do pass, they did pass the assembly. We're still waiting for the Senate, and that could take a little bit. But assuming it does pass, some things stay the same. The definition of employer and employee is essentially the same. There's little tweaks, but it really covers almost all employers and employees in New York State. It still prohibits these employment promissory notes. So essentially, any contract that requires an employee to pay something if they leave employment before a stated period of time. But what it really does do is expand the exceptions to that. So this idea, oh my gosh, I can never have an employee sign any agreement where they have to repay something at some point. That's not the case. It's a more limited, well, the definition is still expansive, but the exceptions are expansive as well under this law. So Anna's going to talk about a lot of those exceptions. The big one, though, and this goes along with the governor's statement, is it clarifies that an employer can require an employee to reimburse the employer for costs related to tuition, I'm reading this, fees, and required educational materials for certain types of training, so long as those meet certain conditions. So there's going to be a distinction here you have to think about. If you have an internal training program of some sort that the employee needs to do that specific job for you, and you charge some sort of fee or something like that, that's impermissible at this point. However, if you have some sort of tuition reimbursement program where an employee can go get a credential or a diploma, and Anna's going to talk more about this, don't want to step on her toes, but they get an MBA that they can use somewhere else. That's one of the exceptions that is still okay, and you can still do that. Now, you want to make sure your language is good on the agreement, but that distinction is now clear that it's not any type of training, any type of education. It's more limited than what the original language looked like it might be.
Yeah. So, to Ben's point, you don't need to scrap your tuition assistance programs, or even some of the other types of provisions that you have that require repayment. But you do need to take a look and make sure that they fall in line, with the new requirements or the potential new requirements of these proposed amendments. Now, we have a pretty good idea that these proposed amendments are going to pass, because of the governor's approval memorandum. We've just heard some scuttlebutt that they're very likely to pass. So it's probably safe to use the updated proposed amendments to look at your current programs and see if they fall in line with the law. But because of the little bit of ambiguity here we have with the current law and the proposed law, you may also just want to keep an eye on what the proposed law says as well.
Yeah, I would
Maybe
just I would just jump in on one thing on that.
Mhm.
Like Anna said, we think the amendments are going to pass. They won't take effect until later in the year. So
That's right.
assuming they pass, there's going to be a period where the law is actually not really in effect, and you can
Mhm.
figure out what you want to do next. But we are in this weird limbo state. Today, the original version of the law is still on the books. So if you have an employment repayment agreement where you say you got to pay me back for training, I would be hesitant to file that lawsuit today. You might want to talk to us and we can figure out what we do next. But for right now, just hold tight. Let's not send any mean letters to employees saying that they owe us money until we figure out what the next step is. But Anna, why don't you talk about the exceptions as well?
Yeah, so specifically to have a tuition repayment program, there are very specific things that you need to do or make sure your program does, under, again, the proposed amendments. So first of all, as Ben just pointed out, the program has to be limited to costs for tuition fees and required educational materials, and specifically for what's called in the law a transferable credential. So a transferable credential, it has a pretty long definition, but basically what it boils down to is that it's some sort of certificate or degree that you can apply not just to your current employer, but to your future career. So, for example, if you are in the process of taking your CPA certification test, so it's something like that where your current employer certainly would have a benefit if you have this additional credential, but you can take that credential and leave and go to a different employer, and it would still be a benefit to you. So some sort of, again, degree or certification that you can apply elsewhere. So it can't be, because of that, employer specific training or education, something that would only be applicable to your specific employer. It has to be sort of more broadly applicable, that would allow you to advance your career if you happen to leave your current employer. Um, so in addition to that, the agreement also has to be set forth in writing, and it has to be separate from any contract of employment. So you can't bake this into somebody's offer letter or employment contract. And it also can't require this agreement for the tuition repayment program. It can't require that the employee obtains that credential as a condition of employment. So you can't be tying the conditions of this agreement to the employee's employment so that they feel like they're stuck in the current job because they have to get this credential or because they have to repay the expenses that the employer shelled out for the credential. So the next thing that you have to make sure that you do in this type of agreement is you have to make sure to specify the actual repayment amount. So you have to spell out what exactly are the costs that the employee would have to repay if they were to leave within a certain amount of time. So let's say it's the employee has to repay X amount of money that was used for tuition and books for this type of certification if they leave within 12 months of finishing the certification program, something like that. Um, and the agreement should also provide for a prorated repayment. So that would mean that if the employee stays for 11 of those 12 months, you can't require the entire amount of the tuition fees to be repaid. You would prorate it so that they've essentially sort of worked off what you would otherwise be requiring them to repay. You also can't require an accelerated payment schedule. So essentially what that boils down to is the repayment plan has to be fair. It has to take into account the fact that the employee sort of worked off a certain amount of time. And then finally, the agreement can't require repayment in all circumstances, which means you can't require repayment if you have fired somebody or the employee has otherwise been involuntarily separated, unless that separation was for misconduct. So if you fire someone for cause, you can still require repayment. But if you fire someone because you don't have a position anymore for that person, business circumstances have changed, something that's not within the employee's control, and they haven't themselves voluntarily left, you can't still require someone to repay. I just saw a question come in that asked, for example, if someone is getting their CNA, their certified nursing assistant license or an LPN license, are those transferable credits? And yes, I think that's right. I think those would be transferable credits because those are things that you can take and apply to any other job where you would need a CNA or an LPN certification. So yes, short answer is yes. I think those would be acceptable.
Yeah, I think when we take a step back, most employers with their tuition reimbursement policies and things like that, these are generally for transferable credit or transferable certifications.
Yeah.
I think it's actually pretty rare that an employer requires an employee to receive some sort of paid training for something that only applies to the job. But we see it. There are manufacturing sites where there's a specific process that needs to be done to cut a diamond, something like that that's only for the specific product that this employer produces, where that's where the training kind of comes up into play. So I think for most people, this exception Anna's talking about is going to be helpful. But remember, the exception only applies if you followed all these steps. So it isn't carte blanche. Oh yeah, you can continue to have tuition reimbursement or repayment program. You can only have that if you follow these steps and have this written policy and get the employee to sign off and have, follow these things. So I think that's really key. We had another question is what if the costs aren't fixed? For example, our relocation agreement is executed before all moving costs are known. We'll get to that exception for relocation. That's a little bit different, but we'll get into that. And we just had another question about relocation bonuses. We'll get there right now when we talk about
Yeah,
other
I was
exceptions.
going to say what I just talked about was specific to tuition expenses. There are other exceptions where everything I just listed out does not apply. And it is another exception to the law, but all of the conditions I just listed out do not apply specifically to these other exceptions. These other exceptions will work differently.
Yeah, and remember the initial purpose of the law, even though it was defined the Trapped at Work Act and talked about these promissory notes, what the legislature was thinking about was these training issues. It's just because it was broad, we thought about all these other things. But there are other exceptions, so we'll talk through that now. The other exceptions to the law. So Anna talked about these trainings for credentials. The other one is any agreement that requires an employee to pay the employer for any property the employer has sold or leased to the employee, as long as the sale is voluntary. So if an employee buys something from you and there's some sort of repayment agreement, that's fine. But it should be in writing, it needs to be voluntary. And remember, New York has very strict limits on deductions from wages. So even if you've made a sale to an employee, you still may not be able to recover that through deductions. You just may be able to have an agreement that the employee can repay. Agreements and collective bargaining agreements are exceptions. Those are allowed, repayment agreements. Agreements that require educational personnel to comply with terms of a sabbatical leave. I don't know if that's going to come up for most of you on here, but if you're a higher education entity and you do sabbaticals, we can talk through that part. And then this one, I think, gets to a lot. We're getting a lot of questions now about this. An exception to the law is an agreement that requires an employee to repay a financial bonus, relocation assistance, or other non-educational incentive or other benefit or payment not tied to specific job performance unless the employee was terminated for any reason other than misconduct or the duties or the requirements of the job are misrepresented to the employee. That was a mouthful, but essentially, again, employers are not prohibited from entering into an agreement about repayment of bonuses, relocation payments, payments for educational credentials, like we said, but there are exceptions to that. It needs to be a written agreement. If you fire somebody because of a layoff or just because of not meeting performance expectations, you will likely not be able to recover that money. It's only if they quit or they're terminated for misconduct. So a lot of your policies are probably in principle okay. You say, I'm paying you this relocation bonus. The policy may say, if you leave employment for any reason within 1 year following you starting, that would probably need to be changed to say, if you quit or you're terminated for misconduct, then we need to change that. So again, assuming these amendments pass, we have a few months to figure out exactly how we need to change that language, but we do need to make sure we're updated from that standpoint.
And I think there are a few questions about amounts and period of time to repay. While these non-educational repayment provisions that can be acceptable, as Ben just explained, are while these do exist, and while the requirements that I talked about for tuition assistance don't necessarily apply to them, I would still encourage people to think about a prorated schedule of repayment and a reasonable period of time that someone has to work before they've sort of worked off this expense. Partly just for fairness to the employee, and partly because I think that it makes sense to treat your repayment agreements in a similar way. So what that boils down to is there is no specific period of time for repayment. Just whatever is fair, I think, is sort of the general common good practice advice. And then you don't necessarily have to spell out the amount that someone has to repay if it's a non-educational repayment plan, but it would behoove you to do so because the agreement is much stronger in terms of enforcement if you can say, we agreed on this amount to be repaid rather than some ambiguous amount. So that would be, it's helpful to do that. if you're looking to actually enforce the provisions. Just a few more things about penalties and enforcement, and then we'll do some quick discussion on next action steps, although I know, Ben, you've already sort of talked about things you might want to think about. So in terms of penalties and enforcement, the Department of Labor is able to accept complaints or take enforcement against employers that violate this law. Of course, in what form, we're not exactly quite sure at this moment, but there are monetary penalties between $1,000 and $5,000 for every violation. The updated law does have some considerations for the size of the employer, whether or not the employer had a good faith basis for believing they were in compliance. So there's a little bit more built in to allow a little bit of leeway for employers if they didn't realize that they were violating the law when they entered into whatever provision we're talking about. Um, so I'll turn it back to Ben since we just have a couple more minutes to talk about things you might want to think about as you're sitting down with your current policies and deciding what to do at this moment.
Yeah, just a couple other things. We talked about how the amended law, assuming it passes, has a delayed effective date. I don't think we
Mhm.
specifically set that date. It would be December 19th, 2026. So
That's right.
we're in a weird, we talked about this limbo period. We're in a situation where the current law is in place, but we think the new amended law is going to pass soon, in which case this last 3 weeks of the law being in effect kind of disappears. And then the law won't be in effect until December of this year. Um, but that's what we think, but you never quite know with New York State. But just keep that in mind and keep an eye on this. With potential next steps, again, let's wait and see if the chapter amendments pass. We think they are going to pass, but if in 2, 3 weeks they've stalled out in the Senate and nothing has happened, well, then in our next webinar, we're going to get on there and say, hey, maybe we have to rethink what we talked about last month. But for now, hold tight, don't sue anybody. Don't send angry letters, but let's figure out what happens next. Uh,
Eh,
when
yeah, no, sorry, Ben, go
yeah,
ahead.
when we get to the amendments, assuming they do pass, I think whether it's part of your handbook review or your policy reviews, I think it's time to do an audit and look at what types of repayments we require, if any, in your company. And then we can go through the checklist. We can help you with that. Your HR team can help you with that. But what do we do about tuition? Do we have relocation bonuses? All those things. And just think about any instances where an employee may need to repay. We don't think you need to scrap all those programs, but we may need to tweak some things. We may need to send some follow-up letters to employees and say, hey, in your offer letter, you agreed to this. We want to clarify that if you are terminated without cause or if for any reason other than misconduct, you don't have to repay this. We need to think about how we document things in a way to make sure that your future actions are going forward. And again, the enforcement is done through the Department of Labor. So if you can show your practice is compliant, and even if you have an offer letter from 10 years ago that may say something improper, we just need to think about whether it's worth it to reissue that letter or kind of let it slide. But it's going to be different for every employer, and everyone's going to have to decide kind of how forceful an approach they want to take on this. We did get a question about whether there's a law in New York State that says deductions from wages are generally prohibited unless they fall on a list. And there's one sentence in that law that says if an employer requires a payment as a separate transaction that would otherwise be prohibited as a deduction, they can't do that. That's an improper payment as well. Somebody asked if they think that law is going to be updated to reflect this issue that you can make these separate payments. I don't know the answer, but my guess is no. New York isn't really great about going back and fixing ambiguities in the law. But if the law is clear that we can require certain payments like this, I think I'm okay following that part of the law.
And I'm just going to jump in and quickly give everyone the code since we're at the top of the hour or a minute before. So I'll throw it up on our screen here so that you have them. And I'll read them aloud as well. So for HRCI credit, the activity code is 731272. The SHRM code is 26-WT75A. And the CLE code is trapped, which is TRAPPED. So you can enter the HRCI or SHRM codes into their respective portals to submit for credit, and you've got the CLE code as well. Yeah, on that last point, I think that uh, it. I agree with Ben that I don't know that we'll see an update to the deductions law. There's also uh, regulations about what to do with loans that you give to employees, and this definitely sort of crosses over a little bit on that topic. But I think it's just going to be a matter of figuring out how to fall in compliance under both of those sort of parallel laws at the same time, rather than seeing any updates. This may also be a good opportunity to take a look at your practices for overpayment deductions, for completing separate transactions with employees who need to repay things, and for if you have a program to advance money to employees or have a practice of doing that, might be a good idea to take the time to make sure you're in compliance with those very specific deduction and overpayment rules that New York State has. We are at the
I could
top
just
of the hour. Sorry,
I can
yeah.
just jump in one sec. I think from a very high level, when this law first passed and we started reading about it, it was like, oh my gosh, this is going to change everything. I have to get rid of all my old agreements. I think assuming these amendments pass, a lot of the things that you're doing, sales incentives, relocation payments, retention bonuses, we can still have a process in place to have employees repay those if they don't work for you for a certain period of time. We just This is going to be a reminder that we need to put things in writing, we need to be clear, and we need to make sure these are reasonable. We need to make sure that they're fair. And if we do that, you'll be okay. We can still recapture a lot of the stuff. The other secret is most employers never sue employees over any of this stuff. So sometimes we put this big bad language and you have to repay me, you have to do this. We need to take a step back and think, are we really going to require this? Are we really going to go to the mats over these things? And if in practice you haven't done that, this may be a time to rethink how we want to approach this issue in the first place.
Yeah, that's right. For those of you who there was a handout that was sent out prior to the program. There are a couple corrections that need to be made. So for those of you who received the handout, you'll get an updated version very shortly. I just wanted to thank everybody for joining Ben and me this morning for this webinar. Keep an eye out for an email following the session for our next date and topic. And we really appreciate, as always, you tuning in every month. It's always great to be able to share these updates, especially when we've got one that happened so recently. So thanks again for joining this morning, and I hope you have a great rest of your day. Stay safe,
Bye,
everyone.
everyone.